In this video, we're going to finish off talking about the various different methods and forms and types of dispute resolution and alternative dispute resolution that you have available to you that you will advise a client on where a dispute may or may not arise. This video is going to focus on the one that we're going to be spending the majority of our time doing, the one that is the most legally intensive, let's just say. This is, of course, the issue of litigation. So we've focused on mediation, we've focused on arbitration. This video will focus on litigation. Now we're only going to take an overview to litigation because really the whole course that we're talking about from basically the start from here to the end is going to be concerning various different aspects and conversations concerning litigation. So that's what's important to remember. So, as an introduction then, what happens if the parties to a dispute tried their very, very best using the alternative methods, but they are just unable to resolve this dispute? They just cannot meet the two conditions or whatever, the position that one side is on and the position the other side is on. They just cannot get them two positions to meet and to come to an amicable conclusion. What happens then? Well, if the dispute still persists, because it might be the case that the claimant who feels like they have a dispute, even if they feel like they've got a very valid claim to a dispute, and they think that they would likely win if it went to litigation, they might decide, you know what, it's not worth it. It's not worth litigating. It'll be too costly. There's no point even suing this particular defendant, etc., etc. So if the parties to the dispute still persist, if the dispute still persists, then the parties may choose to initiate litigation proceedings. Now, even here, the parties are still encouraged to reach a settlement of the dispute before litigation takes place. So we will spend the next few lessons talking about ideas concerning limitation. So the idea that you can't just bring a dispute up that has elapsed for many, many years, okay? And we will also talk about the pre-action protocols, the things that need to be done, the best practice in mind that needs to be considered when a litigation is taking place. And involved in that, in deep embedded within all of the pre-action protocols and even the practice direction of the pre-action protocols, is this encouragement that they have tried everything they possibly can to resolve the dispute through ADR, through alternative dispute resolution. So if no such dispute is reachable, then the court will impose a solution to the dispute which will be binding on the parties. So if a resolution is unreachable, despite the fact that they started with, let's say, mediation or whatever, and then they carried on with negotiations and stuff, and they went through the whole process of litigation, they were even encouraged early on in litigation to continue to resolve the dispute amicably, then dispute will be imposed upon, a solution will be imposed upon by the courts. Now, the civil procedure rules of 1998 are going to be things that it's going to be a document or a sort of a practice legislation, should I say, that should be familiar to you. You should be getting yourself familiar with it. Bookmark it on your Chrome tabs or whatever, and make sure you familiarize yourself with lots of the different aspects of it. We will talk about this and go through each of the various different aspects of the civil procedure rules throughout this series of videos. But fundamentally, you'll become very, very familiar with these rules over the course of this series of videos, because essentially what the civil procedure rules are a set of procedural rules which determine how cases in civil disputes are to be handled. Simple as that. The aim of the civil procedure rules is to deal with civil disputes in a way that adheres to the civil procedure rules' overriding objectives. So at the start of the civil procedure rules, they have clearly set out a number of overriding objectives, and I'll get to them in a second. And so fundamentally, the process of a dispute in civil litigation will follow the process of the civil procedure rules. They essentially outline how these different kinds of disputes are to be dealt with and handled. So section 1.1 or part 1.1 of the civil procedure rules outlines for us the overriding objectives, and they look a little bit like this. It says, these rules are a new procedural code, not very new anymore, given that they are 27 years old, but nevertheless, they are a new procedural code with the overriding objective of enabling the court to deal with cases justly. Dealing with cases justly includes, insofar as practicable, ensuring that the parties are on an equal footing, saving expense. I'll go through actually these one bit at a time. So if you remember back to earlier lessons, one of the things that we noted as a relative disadvantage of, let's say, mediation is the fact that often the parties to a dispute have relatively imbalanced power dynamics. So sometimes it might be a small individual who is trying to sue a big conglomerate, or vice versa, or something like that. And so it might be the case that in mediation, for example, they are not on an equal footing. It feels like a very David versus Goliath kind of case. Well, one of the overriding objectives of the civil procedure rules is to ensure, as much as possible, as so far as practicable, that the parties are to be on an equal footing, so they can actually be dealt with this. They can deal with this case in a just manner. To try and save expense. So at all stages, even in litigation, even though litigation is very expensive, they try to save expenses as much as possible. To deal with the cases in ways which are proportionate to the amount of money involved, to the importance of the case, and to the complexity of the issues, as well as to the financial position of each party. So if you have a case with two huge conglomerates that are dealing with a major international issue that is very, very complex and very, very important, then they will deal with the procedure rules, tell the courts to deal with those kinds of cases in a way that is proportionate to that kind of scale. If it is a very small case between two individuals, let's say, or between two sole traders, where it's not a very large amount of money, it's not a particularly complex case, it might be just a very simple, contracts dispute, for example, and let's say there is a relatively low level of financial positions of each party. They're just sole traders. Let's say there's you've got a plumber versus an electrician or something, who aren't earning the kinds of money that a huge conglomerate is earning, for example. Then they would deal with that case in a way that is proportionate to that kind of scale. On the other hand. And then finally, ensuring that it is dealt with expeditiously and fairly, so quickly and fairly, allotting to it an appropriate share of the court's resources, while taking into account the need to allot resources. So again, making sure that the court actually deals with the case in a way that is fair and just, involves the court spending an appropriate amount of time looking at the case and examining the case and dealing with the case. And so fundamentally then, these are the overriding objectives that are associated with the civil procedure rules. The next few videos, what we're going to do is start to look at the next part of the SQE specification, which outlines for us what are essentially the preliminary considerations that are necessary for the initiation of civil litigation, which means we have to talk about the idea of there being a course of action. We have to think about the idea of identifying a defendant. We have to think about the choice of forum. So in a lot of cases, of course, there are international issues that we have to deal with. We are no longer in the European Union, for example, so if a case involves a dispute in one of the EU member states, we cannot rely on the EU's rules to deal with that case. And then we also have to think about the idea of limitation. Has the dispute essentially elapsed out of the limitation period? And then thinking about the pre-action protocols, the things that the parties need to do or ought to do before coming to a dispute in civil litigation. All of those are issues for the next video.